Hi, this is Randy Kattis from Katniss & Wells, and today I want to talk about privileges in the context of litigation, particularly estate and trust litigation. When a lawsuit occurs, there are what we call privileges. When an attorney is speaking to a client, there's what's known as the attorney-client privilege. So any communication between the attorney and the client is not discoverable, meaning you can't use it in evidence at trial or in pretrial matters. Doctors also have this privilege. It's a doctor-patient privilege. Interestingly, CPAs do not have this privilege. So when you're talking to your financial consultant, your certified accountant, certified public accountant, or other financial advisors, remember there's no privilege when you're speaking with them, not like a doctor or an attorney. So be careful when you're speaking with them if you get in this situation involving a trust and estate dispute. Now, in certain types of litigation and trust litigation, what I just said, there are exceptions to it. What are those exceptions? If someone challenges a trust or a will, they have the right to see the communication of the attorney with the prior trustee or the person who set up the will. So that's contrary to what I said earlier, which is normally the attorney-client relationship, it's privileged, you can't see the information. But if you're contesting a trust and a will and you say to the court, listen, I want discovery from that purported trustee, I want discovery from the attorney that assisted them, I'm challenging the trust, the law says you have the right to all of that information. On the other hand, once a new trustee takes over, this is after the person dies and the trust is final and there's a new trustee, that the courts say that communication is still privileged and confidential. So the point of demarcation is very simple. When the person dies and the trust is challenged, the communication with the lawyer who was involved, if any, before the person died, you get to see. If the person dies, there's a new trustee, a new attorney, and they're trying to defend the trust, that information you don't get to see. However, there are other exceptions that if the court says, no, I still think you get to see that, the court can make an order that you even get to see that as well. Financial privacy. In California, there is a privacy protection for financial privacy, for your personal financial affairs, but also for your tax returns. Once litigation occurs involving a trust or an estate, generally you can get the tax returns, you can get the financial instruments, and remember, as I said, there's no privilege with a certified public accountant or financial advisor, so you can also get all of that information as well if you're in litigation involving a trust and estate. Remember that there is an overall requirement of relevancy. So the first thing that you need to understand is if you have an attorney and you want to get certain information, if you're going to have a lawsuit, it has to be relevant. In most cases, if you're challenging a trust and a will, the communication with the prior people who set up the trust and will all be relevant. The attorney will be relevant. Doctor information, if the person was being treated by a physician, it's relevant. That's another exception. Remember I mentioned the doctor-patient privilege. Well, if the elderly person has passed away, they're no longer around, and the issue comes up, did they have dementia, or did they understand what they were doing? All those medical records are discoverable, and the privilege doesn't exist as to those records. So just keep in mind, if you are considering bringing a challenge to a will or a trust, and your thought is, well, can I get the information from the lawyer? Can I get the information from the hospital? Can I get the information from the bank? The answer is yes, and you need that information to support your claims if you are claiming that the person who made the will and the trust didn't know what they were doing, there was undue influence, or there was some other problem that you contend makes the will and the trust unenforceable. If you have any questions on this, feel free to call our office. We do offer a free consultation, initial free consultation. Again, my name is Randy Katniss, Katniss & Wells. You can reach us also at our website at katnisslaw.com. Thank you.